And thank you all for your presentations today and your contributions to our work. As the Chair alluded, 23 years of iterations of this legislation and then 18 months, I guess, of work has gone into preparing what is just a draft. I come from the public representative perspective and dealing with lay people and constituents who are trying to engage in the whole planning process. And I suppose they have a number of opportunities in development plan process, when there's a specific planning application with their local authority, and then if that's appealed to on board Planola, and then finally they end up maybe with yourselves or your colleagues. But it's thankfully a very small percentage of developments that end up in the courts. And I suppose what we really want to try to do in amending this legislation is create greater clarity and certainty and consistency to our planning developments. So dealing with the legal aspects of this is really, really important that we get that right. And I suppose for my opening questions, there's two areas I'd like to focus on. One is this issue of locus standi. So basically, I suppose people having a legitimate position to engage in a legal way on a development. And can you just clarify for me, the way it's currently drafted and the way it's proposed, if individuals or groups had either made a submission on the development in the development plan, or if they had made a submission in a planning application to either their local authority or on board Planola, would that automatically qualify them as having legitimacy, a locus standi, as you describe it?
The mere fact of prior participation would not appear to be sufficient in the sense that, and leaving aside the materially affected point, because it says that an applicant shall be regarded as having a sufficient interest in any ground that relates to matters raised by the applicant in submissions before the decision maker. So as we read it, provided and also you have to have legal capacity, as we read it, you will have a sufficient interest to raise grounds in judicial review proceedings, provided they relate to matters raised by the person in submissions before the decision maker. So prior participation of itself would not appear to be sufficient. You'd be limited to the grounds relating to matters that you'd raised.
Okay.
I think that can raise certain questions because, of course, you can't always anticipate potentially the difficulties with the decision until it's been made. And I think it potentially also raises the prospect of people feeling they'd better kind of raise everything, even if it's just touching on points. So there might be a concern there that it's going to lead to sort of quite pro forma, or you could say defensive submissions to try and say
cover everything.
To try and cover everything, to then try and get standing through this particular provision.
Okay.
So that's our understanding of it so far.
Okay.
Yeah.
So broadening of the language, or broadening, how would you propose fixing that?
Well, I suppose that some people would have different views as to whether that ought to be fixed. But I think maybe the Supreme Court judgment in Grace and Sweetman is helpful there, in the sense that, you know, it generally indicates that if you've got proximity to the development, or if you have participated in the process, that will give you general standing. And then there's some quite, I suppose, mature or developed case law around whether you might be able to raise new points at the later stage. If you wanted to make it simple, I suppose you could say that prior participation in the process would confer standing to challenge the decision, and that is, I think, the general understanding of the Grace and Sweetman judgment of the Supreme Court at present.
Okay, thank you. Okay. Tom?
I broadly agree with that proposition. I presume that, you know, when you look at the idea of standing, what's standing, and should you be restricting standing in planning legislation, I presume it depends. There are very different perspectives on this, and there are policy choices to be made in relation to it, subject to confinement of obligations under the Aarhus Convention and EU law. But you can argue that you're entitled to restrict in relation to it, but you can make a contrary argument, which some people would do, is that there should be very light restrictions, because this is public legislation. It's a matter which deals with the public interest. Every decision is a decision of public interest. And I mean, if, for example, somebody proposes an extension to Trinity College, for example, and for whatever reason, maybe I'm abroad at the time, and I don't make a submission to the planning authority or the board, and subsequently I see a decision which I strongly believe to be incorrect. Should I be excluded simply because I didn't participate? There's an argument in relation to that. People sometimes say, should there be a geographic restriction? Should you say that, somebody from Donegal shouldn't be allowed to object about, an extension to Trinity College? It should only be people within 20 miles, 30 miles, 50 miles. That's just an example in relation to those matters. But again, the contrary argument, and this is a policy choice, is that this is public legislation, that in a sense, the planning domain and planning decisions, and many of these have very substantial intergenerational impacts, a wind farm, a bypass to a road, they have environmental impacts, they have climate change impacts, they have amenity impacts, large-scale housing developments change the character and raise amenity questions in relation to it, and such that, these are public issues, so therefore you should have a very lightweight restriction. But that's kind of a policy choice in relation to it. There's an attempt here to restrict, it seems to us, narrow down the substantial interest definition, which in the short term we think would be probably counterproductive because it will lead to lots of litigation around that.
Okay, so am I out of time? Or? So then if we, I would agree with you. I think if it's a public matter, then public participation has to be maximised. But I suppose then you have the conflicting objective or ambition of trying to make our decisions more efficient and so more productive, so we can actually have developments.
Sure.
It's one thing engaging people in the development process and having opinions, but it's equally, if not more, frustrating for them to have engaged in it and then actually to see no development, good, bad or indifferent. Sure. So then in terms of the timing, you raised a concern about proposed statutory timings.
Yeah, well, the first thing to say is that under the rules of the court and under practice directions that the current judge of the planning division of the court, of the High Court has, there are actually default directions, and what's happened is parties often agree, or in an interaction with the court, having regard to the case, say this is what we are going to propose, and the judge can adjudicate on that if it's reasonable. The problem with a one-size-fits-all set of time limits is one size doesn't fit all. Some cases are very net and fine. You can put in your statement of opposition within 3 weeks, but if a case can raise really, really complex issues, and you can't do that in relation to it. So I presume the point we're making is that we think this is probably something that's better left over for rules of court and a degree of flexibility given to the court in relation to it, to deal with it.
The subject of